Condo and homeowners associations were not intended or created to be oppressors of home living. And listen to this stat, this might surprise you. As of 2023, nearly half of Florida's 8.6 million homes were part of a homeowners association. Now there's changes on the horizon. As of July 2024, new regulations went into effect to protect the rights of the people in these homeowners associations. I'm Larry Mastrapiri, broker owner of the Mastrapiri Group right here in South Florida. Let's talk about how this affects homeowners. What's been going on is the Florida State Legislature recently passed several key bills intended to increase transparency, improve education and literacy among condo owners and condo management, and also limit association regulation. Of the three bills that were signed and passed into law, we're going to focus in this video on House Bill 1021, known to many as Condo Bill 3.0. So what does this bill really do? For starters, it addresses a number of concerns that have historically come up. Example, when a HOA resident is elected to a board member position, how does the community really know that this person is qualified for the role? Sure, they may have communicated that they worked in some related field and that they would be a great fit, that they really know what they're doing, but don't we need some kind of proof? South Florida attorney Karatanis, who specializes in association law, says that moving forward, associations and board members will have required education to complete when they're newly elected.
Previously, board members were allowed to just sign a piece of paper saying that they understood what they were supposed to do, and many of them were just faking it. There was no standard for educational requirements. At least now we have a benchmark for what board members need to know.
So even if someone tries to fake it until they make it, an HOA board member must complete at least a 4-hour course with a licensed provider under the Department of Business and Professional Regulation. This course will cover financial topics related to condo regulations and laws, and it's required to be completed within the first 90 days of an association member taking the new position. Now, it's obviously uncertain how effective this course will be and how it will even be policed, but I think it's a step in the right direction. Now, in theory, we'll have board members that should all know their stuff. But what about the communication piece? Let's talk about that.
They tell us they have a board that doesn't hold regular meetings.
These people become powerful and they get to a certain point where they become untouchable.
Fortunately, transparency is a big part of the Condo 3.0 bill. In buildings with at least 10 units or more, board members are now required to meet once a quarter, 4 times a year. Historically, it was not uncommon for board members to meet only 1 time a year.
Now the members can attend the meetings and specifically ask questions about how the finances are being applied, how the projects are being run, the status of any kind of construction agenda.
And no secret meetings either. Anytime a majority of the board gets together going forward, they are legally required to memorialize what is said and discussed by recording the meeting minutes. This is a big thing. If you sold as many condos as I have, you know getting clarity, getting transparency on what is happening in the community for your buyer or for your seller is a huge piece to selling that condo. If you've recently watched some of our newer videos on these association laws, you're probably aware that now associations are required to make all pertinent documents related to the association readily and immediately available online. This will typically be done through a website portal as an example. Prior, this rule only applied to condominiums with 150 or more units. Now they've dropped that requirement down to 25 units or more. This is awesome. Unfortunately, the implementation of this rule is not required until January 1 of 2026. This date cannot come fast enough. I, no joke, have someone on my staff that their sole responsibility is to chase down condo and HOA docs for our clients. That's all they do, 40 hours a week. I cannot wait until these associations are required to get their act together on this front. This next one might seem small, but it's really not. These new structural reserve studies that are required for certain condo buildings. When the board receives the final copy of the structural reserve study, they must report it, disclose it to everyone, all the members of the association within 45 days. So if the building has structural issues of any kind that have been noted, it cannot be kept from the residents. This is pretty important. When we're representing buyers, as an example, buying a condo unit, they really need to know the status of repairs and maintenance in the building. And this really helps answer those questions, the structural reserve study. On the flip side, when you're representing a seller, you want to be prepared to answer any questions buyers might have. You want to understand exactly what you're selling and the condition of the community. And if the news is really good, well then that's a selling point for the condo. Okay, moving on, let's forget about the Kens and Karens trying to overregulate their associations for one moment. Let's talk about the legal corruption of associations that have really taken center stage here in Florida.
Former members of an HOA that oversees 40 communities in West Kendall were taken into custody accused of stealing millions.
How does this new legislation attempt to prevent this? Well, for starters, accepting bribes and kickbacks is now a felony offense. Previously, a board member had to be convicted in order to be formally removed from the board.
Condominium Association president embezzled thousands of dollars from residents.
But until that investigation is complete, Murphy will remain as president.
Now, a board member merely charged with a crime will be forced to resign. And these new enforcements don't stop there.
If an association or the manager fails to give records at least twice in a calendar year, you're looking at criminal charges. This is an uptick from what used to just be a civil penalty. So if the association wanted to really hide something, all they could do is just say, oh no, we don't have it, or it's not available now, and then pay the monetary fine. That's not even a possibility anymore.
These new association laws are a super hot topic right now. So feel free to weigh in the comment section below. I'm super curious to hear your thoughts. And if you like the content, please give me a like. If you want more content just like this, hit subscribe. We're putting out videos every week. And real quick, don't forget, if you're looking to buy or sell a home here in South Florida, we'd love to be your real estate resource of choice. Don't hesitate to reach out. I'm Larry Mastrapuri, broker owner of the Mastrapuri Group based right here in South Florida. I'll see you guys on the next video.